You slipped on a wet floor at a grocery store. Your back hit the ground so hard you couldn't breathe for a second. Someone rushed over and said, "You should sue them." And you stood there, holding your lower back, thinking, "Can I? Is that a real thing, or just something people say when they don't know what else to tell you?" Then a week later, someone brought up that woman who spilled hot coffee on herself at a fast food restaurant and won millions of dollars, and the room laughed. Of course they laughed, because for 20 years, that story has been the punchline for everything that's supposedly wrong with the legal system. Clumsy woman, hot coffee, millions of dollars, broken system. Except here's the thing. Almost everything you were told about that case is wrong. The coffee wasn't just hot. It was 190 degrees. It caused third-degree burns. The woman needed skin grafts. She spent 8 days in the hospital. She originally asked for $20,000 just to cover her medical bills, and the company said no. A jury heard the evidence and decided the company had known for years that their coffee was dangerously hot and had chosen to do nothing. The millions in the headline were punitive damages, reduced by the judge, and the case settled for even less. But nobody told you that part. They told you the punchline. That's the problem with tort law. Not that it's complicated, it's that the version you've been given is a cartoon, and the cartoon is so loud that it drowns out the real thing. The real thing is one of the most elegant ideas in all of law, and it starts with a question so simple, you've probably never thought to ask it. Here's the truth that explains all of tort law. Everything in this entire area of law comes from two questions. First, when does someone owe you money for hurting you? Second, why isn't every harm automatically a tort? Those two questions have names. The first is answered by something called duty and breach. The second is answered by something called causation and damages. By the end of this video, you will understand both. And once you do, you'll never read a lawsuit headline the same way again. Before we can answer those two questions, you need to see the world they came from. Imagine there's no tort law. None. You live in a world where accidents happen, people get hurt, and the law has absolutely nothing to say about it. Your neighbor is building a fence and drops a hammer on your foot. Broken toe. You can't work for a month. You lose income. You pay medical bills. And your neighbor says, "Sorry." That's it. Sorry. There's no system that forces him to pay for what happened. No mechanism that connects his carelessness to your cost. Your only options are to absorb the loss, beg him to help, or get physical. And if you get physical, now you're the criminal. Now multiply that by every car accident, every medical mistake, every defective product, every slip on every wet floor in every store in the country, millions of injuries a year. And in every single one, someone is hurt, someone caused it, and the cost has to land somewhere. Without tort law, the cost always lands on the person who got hurt. Always. Even if they did nothing wrong, even if the other person was reckless, the injured person pays. That's the default. Tort law exists to change that default. To take the cost off the person who was hurt and put it on the person who caused the harm, but only when it's fair to do so. That's the whole thing. That's the entire engine. The question is just, when is it fair? Before you can understand duty and breach or causation and damages, you need to understand the one idea that makes both of them possible. The idea is called the reasonable person. In plain English, the reasonable person is an imaginary human being that the legal system invented to measure everyone against. This person has never existed. You will never meet them. No one has ever been them. But every single negligence case in the history of American law has been decided by asking one question. What would a reasonable person have done in this situation? Think of it like this. Imagine a ghost that the judge summons into every courtroom. The ghost is calm, careful, aware of obvious risks, and pays attention. The ghost is not perfect. The ghost makes mistakes. But the ghost never acts recklessly, never ignores dangers that a normal adult would notice, and never does something that an ordinary person would look at and say, "That was careless." Every time someone sues for negligence, the judge turns to the jury and asks, would the ghost have done what the defendant did? If the answer is no, the defendant was negligent. If the answer is yes, the defendant walks. The entire system runs on this one imaginary person, and the reason it works is that the ghost is not a genius and not a fool. The ghost is average. The ghost is you on your most careful day. That's the baseline. Everything in tort law is measured against it. Now that you have the foundation, the two tools are easy. Here's what the first tool does. Duty and breach answers the first question. When does someone owe you money for hurting you? And the answer has two parts. First, the person who hurt you had to have a duty of care toward you. Second, they had to have breached that duty. If either part is missing, the case is over before it starts. So where does the duty come from? This is the part that surprises people. In most situations, you already have a duty of care toward the people around you. Right now, if you're driving, you have a duty to drive carefully. If you own a store, you have a duty to keep the floor safe. If you're a doctor, you have a duty to treat patients competently. You didn't sign anything. Nobody handed you a contract. The duty exists because the law says that when your actions can foreseeably affect other people, you owe them a basic level of care. That word, foreseeably, is doing a lot of work. It means the harm had to be something you could have predicted, not something bizarre, not something no one could have imagined. If you're driving and you hit a pedestrian, that's foreseeable. If you're driving and a meteor strikes your car and the debris hits someone, that's not. Duty is not unlimited. It only extends as far as what a reasonable person could have anticipated. Now, here's the breach. A breach happens when someone falls below the standard of care that a reasonable person would have maintained. Think of duty as an invisible seatbelt you're wearing at all times. You only notice it when something goes wrong. Breach is the moment the seatbelt fails. Not because it broke, but because you never clicked it in. A store owner who knows the floor is wet and puts up a sign has met the duty. A store owner who knows the floor is wet and walks away has breached it. The question is never whether the harm happened. The question is whether the person who caused it acted the way the ghost would have acted. If the ghost would have put up the sign and you didn't, you breached. There's one more layer here that matters. Sometimes the breach is so obvious that you don't even need the ghost. This happens when someone violates a specific law or regulation, and that violation causes exactly the kind of harm the law was designed to prevent. If a speed limit exists to protect pedestrians and you drive 20 miles over it and hit a pedestrian, the breach is automatic. The law itself becomes the standard of care. Lawyers call this negligence per se, which just means negligence by itself. The violation proves the breach without needing to summon the ghost at all. The key point of duty and breach is this. Not every injury creates a case. Only injuries where someone owed you a duty and fell below the standard count. The duty is the invisible line. The breach is the moment someone crosses it. But proving those two things alone is not enough. Because there's a second half, and without it, the whole case falls apart. Here's what the second tool does. Causation and damages answers the second question. Why isn't every harm a tort? And the answer is that even if someone breached a duty, you still have to prove two more things. First, that the breach actually caused your harm. Second, that you suffered real, measurable damages. Without causation, you have a careless person, but no connection to your injury. Without damages, you have a connection but nothing to compensate. Causation sounds simple, but it has a trap. There are actually two kinds of causation, and you need both. The first is called cause in fact. Here's the test. But for the defendant's actions, would the harm have happened? If you can say, but for the wet floor, I would not have fallen, you've got cause in fact. It's a direct link. Remove the action, the harm disappears. The second kind is trickier. It's called proximate cause, and it asks whether the harm was a foreseeable result of the breach. This is where things get interesting, because sometimes carelessness causes harm in ways nobody could have predicted. Imagine someone leaves a bicycle in the middle of a sidewalk. A jogger trips over it, stumbles into the street, and a delivery truck swerves to avoid the jogger and crashes into a fire hydrant, which floods a basement 3 blocks away, which ruins $10,000 of stored electronics. Did the bicycle cause the flood? Technically, yes. But would a reasonable person leaving a bicycle on a sidewalk foresee a flooded basement 3 blocks away? No. That's where proximate cause draws the line. The chain of events has to be close enough, direct enough, and predictable enough that it's fair to hold the defendant responsible. If the chain gets too bizarre, too attenuated, too unpredictable, the law cuts it off. Not because the defendant wasn't careless, but because fairness has limits. And then there are damages. Damages are the price tag on the harm. Without them, there's no case, because tort law doesn't punish carelessness for its own sake. It compensates loss. The most common kind are compensatory damages, which do exactly what they sound like. They compensate you for what you lost. Medical bills, lost wages, pain and suffering. The cost of the harm translated into a dollar amount. Then, in rare cases, there are punitive damages. These are not about compensating you. They're about punishing the defendant for conduct so reckless, so outrageous, that the court wants to send a message. Remember the coffee case? That's where the big number came from. The jury didn't give that woman millions because her coffee was hot. They gave it because the company had received hundreds of complaints about burns, had internal documents showing they knew the temperature was dangerous, and had decided the cost of lawsuits was cheaper than the cost of turning the heat down. Punitive damages exist for exactly that kind of calculated indifference. Think of negligence as a rope with 4 knots tied in it. Duty, breach, causation, damages. If any single knot comes undone, the entire rope falls apart. You can have duty and breach but no causation, and the case fails. You can have causation and damages but no duty, and the case fails. All 4 knots have to hold. That's why not every harm is a tort. Not because the system is broken, but because the system is precise. Here's the part most people never see. Duty and breach on one side, and causation and damages on the other, look like 2 separate tests. 2 different hurdles you have to clear. But they're not. They're the same question asked at 2 different moments in time. The question is, between 2 people, one hurt and one careless, who was in a position to prevent what happened. Duty and breach answer that question before the harm occurs. Was there a responsibility? Was it violated? Causation and damages answer the same question after the harm occurs. Did the violation actually lead to this? And what did it cost? They're 2 ends of the same rope. One end asks, should you have done something different? The other end asks, did it matter that you didn't? And the entire field of tort law, every slip and fall, every medical malpractice case, every product liability lawsuit, is just those 2 questions wrapped around the same core. Who could have stopped this? And what's the fair price of their failure? Once you see that, you can't unsee it. Every tort case you'll ever read is one question in 2 parts. Here's what most people get wrong. The first mistake is believing that if you got hurt, you automatically have a case. You don't. Getting hurt is not enough. You need all 4 knots: duty, breach, causation, damages. Missing even one means you have an injury, but not a lawsuit. A lot of people walk into a lawyer's office with a real injury and walk out with nothing. Not because the lawyer failed, but because one of the 4 knots wasn't there. The second mistake is the coffee case. Almost everyone uses it as proof that the legal system rewards frivolous lawsuits. It does the opposite. Stella Liebeck, the woman in that case, suffered burns so severe she needed skin grafts and was hospitalized for over a week. The coffee was held at nearly 200 degrees, far above what any other restaurant served. She asked for $20,000. The company refused. A jury heard the evidence and made a decision based on those 4 knots: duty, breach, causation, damages. Every single one held. The headline lied to you. The system worked exactly the way it was supposed to. The third mistake is thinking punitive damages show up in every case. They don't. Punitive damages are rare. They're reserved for conduct that goes beyond carelessness into something close to intentional disregard for human safety. Most tort cases end with compensatory damages only. The defendant pays for what they broke. Nothing more. Let me show you exactly how this knowledge works in your life right now. Next time you see a wet floor sign at a store, you're looking at duty of care in action. The store knows the floor is dangerous, and the sign is how they meet their obligation. If the sign is there and you slip anyway, the store has a defense. If the sign isn't there, the breach is almost automatic. Next time you read about a massive lawsuit in the news, run it through the 4 knots. Was there a duty? Was it breached? Did the breach cause the harm? What are the damages? You'll be shocked how often the headline skips 2 or 3 of those and just gives you the dollar amount, because the dollar amount gets clicks. The analysis doesn't. And next time someone tells you the legal system is broken because someone sued for something that sounds ridiculous, pause. Ask what actually happened. Ask what the evidence showed. Because almost every time you dig past the headline, you find a case that makes more sense than the cartoon version. These are general principles, of course. Your situation always depends on the specific facts, the specific state, and specific statutes. If you face a real legal question, talk to a licensed attorney in your jurisdiction, because the framework is universal, but the details never are. Here's what you now know. You know that tort law exists to answer one question. When someone gets hurt, who pays? You know that the system runs on a ghost, the reasonable person, who has never existed but measures everything. And you know that every negligence case is a rope with 4 knots, and all 4 have to hold. The 3 most practically useful ideas are these. First, tort law is not about punishment. It's about who bears the cost when harm happens. Second, the reasonable person is the invisible ruler that measures all of it. And now that you know it exists, you'll see it everywhere. Third, duty and breach and causation and damages are not 2 separate tests. They're the same question in 2 moments. Who could have prevented this? And what did their failure cost? That's the whole thing. That's the elegant machine hiding behind every lawsuit, every settlement, every headline you've ever read about someone suing someone else. Not a broken system, not a punchline, a precise 4-part question about fairness. And the next time you slip on a wet floor, or read about someone who did, you won't just wonder if they can sue. You'll know exactly what the answer depends on. And more importantly, you'll know why. This is education, not legal advice. If you face a real situation, talk to a licensed attorney in your state.